and Sharon Farrell.
3 minutes, please.
You want 3 minutes?
3 minutes, please.
Yes, sir.
The packet was mailed on February 7th, Friday. I received it Saturday morning, the 8th. When I received it, I saw item E1, the CEQA consultant item that's on for action. In that item, it said the request for qualifications and request for proposals has been posted for public review on the district's website. I then went to the back of the packet to see if it was in the packet, and between page 36 and 37, it's not there. So I went on the district website on Saturday, which would be the 8th. It was not there. I went on the district website on Sunday, which would be 72 hours before this meeting. It was not there. I went on the district website Monday morning. It was not there. Monday lunchtime, it was not there. I believe it was posted approximately 4 o'clock on Monday, which was outside the 72-hour period. The Brown Act requires that when you refer in the précis, by reference to a document, it either be in the packet or it be on the website within the 72 hours, and it was not. It's an egregious violation, because when I finally got it, it's dated November 26th. Now, if you look at your calendar for preparation of the packet, every item had to be to Dr. Harder, either by hand or by email, on November 27th at 4 o'clock. So before the packet closed on November 27th, the document existed on November 26th. So it should have been sent with the précis to Dr. Harder's office and put in here. What I'm asking is that this matter can be put on the facility subcommittee calendar next Wednesday, so that it can be reviewed there and then come back on January 9th in compliance with the Brown Act. There's also a second reason. When I read the request for proposal, I saw that the definition of project was too narrow. By making the definition of project narrow, it leaves the consultant to think that it's going to cost less money than it's really going to cost. If this went to the facility subcommittee first, next Wednesday, the definition of project could be hashed out to see whether or not the taxpayers in and around the Castro area, that their definition of project, which is much broader, is actually which one is the more acceptable definition. It may be that the staff's definition in the staff's view is adequate, or they may see that the taxpayer's view is more adequate. The reason that's important is because if you pick a narrow definition and 8 or 9 or 10 months from now it ends up in Martinez in court, and the judge says the definition was too narrow, it comes back and you have to start all over again. So it's actually better to have a sit-down discussion about how broad the definition ought to be, because it protects everybody from having a very bad consequence at the end. So I really think in this particular situation, the best thing to do is it's only be one meeting, put it on for the 19th, and then bring it back on January 9th. Thank you very much.
Thank you, Mr. Brower.
Good evening. My name is Sharon Farrell, and I also would like to state similar concerns that I have as Mr. Brower just did. I was the one that sent an email to Jeff Edmondson on Monday because I too had looked for the request for proposals and couldn't find it. A number of us were very interested to see what the district was going to be soliciting for. And also I have concerns that it is a procedural issue, that it isn't in compliance with the Brown Act. And if I were a consultant and I was asked to submit my proposal on December 5th for the scope of the project as it's currently defined in the request for proposal, I think it would be unfair because, as Mr. Brower has stated, I also agree that the project as defined is way too narrow to what the project really is. And I also would like this agenda item to be reconsidered and actually put on the facilities subcommittee meeting agenda next week.
Mr. Edmondson, can we hear from you on this, please?
Yes, the
document they're referring to the RFP. In fact, they're correct. It was intended to be up before the date, and it did not actually get posted on the website until Monday afternoon. So that is in fact true. No, I don't necessarily agree with the recommendation that the project scope is too narrow, and that's something that can be talked about at greater length if in fact we end up tabling this this item because it wasn't posted.
I think we don't have any choice except to table it because it's posted. I'll actually leave it to you and to our representatives to the facilities subcommittee to decide whether or not this should be agendized as properly the business of the facilities subcommittee, or whether or not there needs to be a public hearing in any venue about this. I'm not sure, and I don't want to get into a discussion now about whether or not we need a public hearing or whether or not the facilities subcommittee is the place to have that kind of an airing of the scope of the project. I'm going to leave that to you to discuss and to get back, certainly to Dr. Harder, with some kind of recommendation in the light of the information that's been presented. And certainly, if we can have a motion to
I'll move to table E1.
okay.
Because it just is not in compliance with the law. So
Exactly.
it's void on its face, and any decision we make is subject to attack and could be thrown out in a court of law.
Thank you. Can we have a second? Okay, all those in favor?
Aye.
Thank you. Thank you both very much for bringing that up.
Well, but we have to go through the rest of the